Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Ricky. He has got a mom that just seems to be counting every penny, and it kind of gets ridiculous. I'll let you guys watch.
Case entitled, Court of Butler County, Kansas. Case entitled, in the matter of the marriage of Jamie Leanne Sundgren and Craig Kelly Swafford. Case number 2019 DM 348. Beginning with petitioner, would counsel announce appearances for the record, please?
Good afternoon, Your Honor. Susie Locke on behalf of the petitioner, Jamie Sundgren.
May it please the court, the respondent, Craig Swafford, appears with counsel Matthew Mantilla via Zoom.
All right.
Sorry, Judge, I struggled with the mute button. May it please the court, Brandy Ridgway appears on behalf of DCF, who has an assignment of child support.
Very well. This matter comes before the court at this time, initiated by a motion to modify child support and for other relief filed back on April the 22nd. It would appear that the parties in this case are wage earners. With traditional employers, income numbers should be relatively clear. What issues of dispute still exist, if any? Ms. Locke.
Yes, Your Honor. There is some contest from the respondent regarding additional pay that he receives, specifically bonus pay. Our position is that all income should be included in the child support worksheet for child support calculation purposes. I believe the respondent's position is that the bonus income should be paid on some sort of percentage basis. The parties ideally and previously desired to resolve this dispute. They agreed in a prior order to exchange their income information by February 15th every year, calculate child support, and make a determination as to whether or not there needed to be a modification. This year, when we received Mr. Swafford's W-2, there was an increase that resulted in more than a 10% increase to the bottom line of child support. So we started talking about a modification, but it was this bonus amount and the request that it be paid on a percentage rather than included in the child support worksheet that resulted in us having to file a motion to modify child support. So our position is that all income is included for child support purposes, that we proceed with modifying child support inclusive of all W-2 income. And then next year, when we receive W-2s again, we determine if another modification is appropriate. So it's that bonus income that's really at issue here today.
Ms. Locke, doesn't the court have authority and discretion to order a percentage share, such as I think what Mr. Mantilla and his client are suggesting to the court?
The court does have that discretion, Your Honor, but it's never exercised it in this case in the past. My client has received bonus income on her W-2 for mentoring. The respondent previously received bonus income from Holly Frontier, now HF Sinclair, and that income has always been included on the child support worksheet rather than paid on a percentage of bonus.
All right. Mr. Mantilla, your response?
Your Honor, the child support guidelines were updated, I think, a year or so ago, and they say that bonuses that are periodically received can be included as part of the monthly income, or they can be paid as a percentage upon receipt. And so in my exhibits, we've got the information showing that when Craig started his job in 2023, he was eligible for a one-time retention bonus, and that was in the amount of $4,000. And so that's what's showing on his end of year pay stub 2024 is the one-time retention bonus. Then he's eligible for what I would call an incentive bonus. And for example, in 2024, he got $246 for that incentive bonus. And then his year to date in this year is $1,776. That's based upon safety, worker safety, customer satisfaction, net operating profit. He works for a manufacturing company. And so a lot of these factors are out of his control. It's not guaranteed, it's variable. And so we are asking that per the guidelines allow that it be paid as a percentage upon receipt. And I've calculated that based on his child support owed, which is $1,068 a month is our proposal. And then his gross income without the bonus is 4,415. If you divide 1,068 divided by 4,415, you come up with 24.19%. And so we've got specific language that I'm proposing the court use, and I've seen it in other orders where that's the way the court handles a bonus, and that way it's fair, because if Craig doesn't earn the bonus, then he shouldn't be expected to be held to that standard of income.
All right. Ms.
Mayor.
Ridgway, do you take a position here?
Your Honor, I agree with counsel that the court has discretion whether or not that is included as income or if it is set aside in a percentage ordered. However, it is DCF's preference that it be considered income, mainly because it becomes labor intensive every year to determine the amount of child support, to get a judgment for that amount, and then allow for payment of that amount. Kansas Payment Center can't simply process a random payment as an addition to the monthly obligation. It is considered an overpayment because there's not a sum specific until a judgment's granted by the court. So that would mean each year counsel comes in, we, file a motion to grant a judgment in this amount. We have a hearing, a judgment, and then that payment could be made. So it's very labor intensive to counsel and DCF to go off of a percentage.
All right. Mr. Mantilla, I trust that on these performance or other bonuses that Craig would receive, there are withholdings?
He's paid the bonus, and then he would have to pay that as a percentage to Jamie. So he would notify her of receiving that, and he's done a good job so far of notifying her of his increases in income. So he would need to notify her of that bonus.
I don't think you understood the court's question. I'm talking about Social Security and other income taxes that would be subtracted from the gross amount when it's paid to the employee. Is that correct?
Yeah, I'm sure that if he gets a bonus that they're going to count it as income, and their human resources is going to deduct it.
So would he be paying Jamie 24.19% of the gross or the net?
It would be the gross amount, because his paycheck should show what his gross is.
All right.
Your Honor, may I respond briefly?
You may.
The challenge that we're having with the bonus that was received in 2024 is Mr. Swafford is refusing to pay that bonus percentage to Ms. Sundgren for child support purposes, even though it was earned, because he was not ordered to do so at the time. This child support order based off the 2024 W-2s essentially takes that moving forward. Takes what he earned in 2024 and adds it to child support moving forward. Annually, obviously, there would be a review as previously ordered of all W-2s and adjust accordingly if that becomes necessary. So our position remains that it should be included for income for child support purposes and calculated moving forward. By way of example, Ms. Sundgren in the past school year was part of a mentoring program that she got extra income for. That income is reflected on her W-2. She will bring in this upcoming when she was doing the mentoring program.
All right, Mr. Mantilla, what's wrong with Ms. Locke's computation here regarding the income of these respective parties?
Well, first off, it's in our exhibits, he got a one-time 4,000 retention bonus. And the guidelines state that let's see, it should be in situations where a payer receives periodic bonuses. So if it's a one-time bonus, it's not periodic. And so that's the issue here, is she's trying to include a one-time bonus as a periodic bonus. And that's not fair to my client, because he's not going to make that much money this year, because it was a retention bonus. Like, hey, you work for us, you stay here a whole year, you get 2 installments of $2,000. And we have the contract in our exhibits to show that it says it's a one-time retention bonus. So that's not fair for him to be expected to earn that every year, because he's not going to. And like I stated, last year he only earned, there's a second bonus, which is the incentive bonus, and he earned $246 last year for that. And this year he's at $1,776. So we don't know what the numbers are going to be, but he's offering to pay it as a percentage, so it would it's not, he's not expected to earn that if he's not, and then he's overpaying in child support. So it's not equitable to do it averaging his income.
We're about halfway through the year. We're just short of it. Wouldn't it be fair just to take this 1776 and multiply it by 2, Mr. Mantilla, as a reasonable projection as to what his overall bonuses will be in calendar year 2025?
Well, we're talking about manufacturing, so he doesn't have control over that. The bonus is based on 1/3 safety, 1/3 customer satisfaction, 1/3 net operating profit. He works in building the airplanes. He doesn't meet with the customers. So whether there's good customer satisfaction or whether the company's making a profit or not, he doesn't have control over that. So it's really just, he doesn't have any control over this. It's really up in the air.
Well, the issue before the court isn't what he has control over, but what is he reasonably expected to make in calendar year 2025? That's the number we're searching for here, Mr. Mantilla. What can we reasonably project that Craig Swafford's income will be for 2025? In other words, for upcoming months and for the future.
Well, if that's the way the court's headed, I think we should just average 2024 and 2025 to date. 2024 was at 246 for the whole year. So if we're at 1,076 this way through this year, we could double that and then average 24 and 25, and there's a fair number.
Very creative, Mr. Mantilla. Ms. Locke, your reaction to that?
Your Honor, the parties already considered this very issue in agreeing to exchange W-2s and talk about child support based upon the prior year's W-2. Both parties have supplemental earnings. Both parties' income are subject to bonuses, we're subject to COVID pay. We exchanged W-2s. His showed an increase, hers showed a minor increase. We modified child support. There's no need for any guesstimations. We base it on the last year's actual earnings. This could have been resolved in February by agreement of the parties had it not been for this bonus structure that came out of nowhere that parties have never considered before. So if we want to talk about actual numbers, the actual numbers are in the parties' W-2s. The parties already agreed to exchange those W-2s, and there's no need to make this any more convoluted moving forward.
The numbers in your Exhibit 1, Ms. Locke, your apparently petitioner's revised child support worksheet,
Yes, Your Honor.
Exhibit 1 that I'm looking at, those were the numbers that you built this worksheet upon?
Correct. The W-2 earnings from 2024.
So you believe current child support should be $1,187 a month?
Yes, Your Honor. And the reason for the revision, we adopted the respondent's insurance provisions. We had calculated his insurance slightly different, so we adopted his, which resulted in a modification and a total support requested of $1,187.
Mm-hmm. How much does that differ from your proposed number, Mr. Mantilla?
Let me pull my exhibit up here real quick. Let's see here. My proposed number is $1,068, and that's based upon Craig's income at $52,980. So it's let's see, about $4,500 less, but then we're asking for the bonuses to be paid as a percentage.
About $179 difference a month, Your Honor.
What number did you just say, Ms. Locke?
Approximately $179 difference, I believe. Sorry.
I thought the two numbers were 1187 and 1068. That's 119 apart.
This is, oh, yes, 119. This is why attorneys don't do math in their head. 119, Your Honor. I apologize.
All right. Wasn't exactly my strong suit either. All right. What troubles the court is the uncertain nature of the bonus structure of Mr. Swafford. We would be projecting income for the year 2025, which may be wholly unrealistic, and there very well may be realistic. We don't know. It's the uncertainty and the varying numbers that he might expect to get this year. Again, probably outside his control under most circumstances. The court is troubled by building that into child support income for 2025 when there's really no reasonable expectation that those numbers are accurate. I do understand Ms. Ridgway's, I think, very, very valid point about trying to keep track of what child support is actually owed and what's actually paid, and the court's sensitive to that. However, at least for the current time, the court's going to adopt Mr. Mantela's point of view in this case. It very well could be that the recipient of child support will actually profit from this court's order. If the bonuses are larger than what was built into Ms. Locke's worksheet today, it could result in a greater child support obligation for Craig than what Ms. Locke even proposes. And I truly hope that it's a good bonus year for him and he makes all kinds of extra money. But the court will order him to pay 24.19% of all bonuses received as additional child support in the case, and adopt Mr. Mantela's child support worksheet, which I believe would call for an amount of $1,068 a month. Now, it would appear then that since he's already received bonuses for calendar year 2025, he's now in a position to immediately pay the 24.19% on those amounts received. Mr. Mantela?
Greg, can you do that?
What
It's his proposal.
The bonuses for 2025, can you pay those within reasonable time? 24.9%?
Yeah.
He says yes, Your Honor.
Okay, what's a reasonable time?
Can you do 30 days?
Yeah.
He says 30 days, Your Honor.
All right, the court does find under these circumstances that would be a reasonable time. And I think it may be important to actually discuss the language to be used in this order. And Mr. Mantela, I think, had a fairly well-drafted provision that he proposed. Ms. Locke, are you familiar with the language of that?
Your Honor, I am, and we would ask that additional income beyond the base salary also be inclusive of a recent workers' compensation payment that was received by Mr. Swafford, and that 24.9% of that workers' compensation settlement payment be also remitted to Ms. Sundgren. That would be part of the language that was already drafted by Mr. Mantela.
Right, are you saying that the language that he proposes on his Exhibit A covers the work comp?
It says, if the respondent receives any bonus, incentive pay, economic stimulus pay, additional income, etc., above and beyond his child support obligation. I believe that the workers' compensation settlement falls into additional income.
Well, actually, workers' comp is intended to be replacement income for income lost. But Mr. Mantela, your point of view here?
Your Honor, he missed 1 week of work and he didn't get paid from his employer. I don't think he worked long enough to qualify for temporary disability from workers' comp. So he didn't ask for modification of child support for that 1 week, but his income never got above his worksheet income for that 1 week. And then he got a one-time settlement payment for permanent partial disability. And I've sent that over to Ms. Locke, that information, and that's part of the quid pro quo of a workers' comp act, is you can't sue your employer in negligence at common law. The quid pro quo is you file a work comp claim. So it's a one-time payment for an injury he sustained. We'll never know if employer was negligent or not in causing that injury, but that's not intended to be replacement income, Your Honor.
But it's still considered income. It's income received. It's $3,111, which is significantly more than he makes in 1 week. And Your Honor, my client did not receive any child support for the bonus received in 2024, the retention bonus. So honestly, in the interest of justice and equity in this case, I think it makes sense that the workers' compensation income received is essentially an offset to her not receiving any child support for the bonus that Mr. Swafford retained in 2024 without having any child support obligation owed on it.
All right, so his eventual W-2 for the year 2025 will be missing an entire week's pay. Correct, Mr. Mantilla?
I'm sorry, I'm having a hard time hearing. I don't know if it's on my end, but can you say that again?
All right. Mr. Swafford's 2025 W-2, his year-end statement of income received, will be missing a week of pay because of his injury, correct?
He was injured in 2024, so I believe that last week was in 2024.
Oh, okay. Hmm. So, okay, to back that up then, the year-to-date income that these child support worksheets were based upon for 2024 missed a week of pay that he otherwise would have had but for the injury, correct?
I believe that's correct.
This court will order in interest of justice and equity that Craig Swafford pay an additional 24.19% of 1 full week's pay that he missed due to his injury in 2024. Now, do we know what the normal weekly pay would be, a 40-hour week?
Yes, Your Honor. Actually, I sent the workers' comp settlement information to Susie earlier today, and she can see what his gross weekly pay is.
Okay, in other words, from his employer, what his gross weekly pay is, correct?
Yeah.
Okay, you have that number, Ms. Locke?
Your Honor, it's $1,198.13.
All right. And the court orders him to pay an additional amount of child support in the amount of 24.19% of that amount of $1,198.13 as additional child support in this case. And that will resolve the work comp settlement issue. Any amount over and above that is essentially a tort-like judgment that Mr. Swafford received, in which, in the view of this court, is not subject to child support.
Your Honor, one more point of clarification. And it involves insurance. My client pays for the children to be on state insurance. She pays $50 a month for that. Mr. Swafford carries the children on his insurance at work, so the state insurance is secondary. Our worksheet included a repayment for her. It included both child support, both insurances on the worksheet. Mr. Swafford's on a high deductible plan at work, so essentially the state comes in and picks up all of the medical that's above and beyond anyone's out of pocket. So it's a huge benefit for the parents. My client had it on her worksheet that both of the insurances were included for child support purposes. Mr. Mantilla's worksheet that was adopted by the court does not include my client's payment of $50 a month for insurance. So
why is that, Mr. Mantilla?
I don't recall that being on her domestic relations affidavit, so I'd have to look at that and see.
All right. I trust that you can provide to Mr. Mantilla proper documentation of that amount.
Yes, Your Honor. My client has requested from his client to be our family wizard every month, half of the $50, and he has never paid it. So both parties are well aware that she pays this amount per month to the state.
Well, it's a relatively low amount, and it should be included in the worksheet upon proper documentation that amount is actually being paid. So I don't know who's going to end up doing this adjusted worksheet, It was Mr. Mantela's in essence. But I think he could probably just rerun the worksheet with an additional $50 entry for health insurance paid by the mother in this case. And that should result in the new and accurate amount. It's a fair point, Ms. Locke. All right, Ms. Locke, anything else?
No, Your Honor.
All right. Mr. Mantella, do you need any further clarification regarding the court's orders?
No, Your Honor, just need to know who's prepared journal entry.
Ms. Locke will be doing that. And I don't think there was any real material dispute regarding the language that Mr. Mantella proposed regarding the percentage share issue. So unless you raise something now, Ms. Locke, I'm going to ask you to include it in its entirety.
Yes, Your Honor.
Okay. As well
Your
as
Honor,
documenting the other rulings and judgments made here today. Now, as far as the, I wanted to just make sure the record reflected it. This additional 24.19% of that 1 week's missed pay due to the work comp injury, is that something that your client can commit to also paying within 30 days, or does he need a little bit more time?
Craig, can you pay that within 30 days?
Yeah.
He says yes, he can pay within
All
30
right, very
days.
well. If you'll include that in the order, Ms. Locke.
Yes, Your Honor.
Okay. All right, Ms. Ridgway, anything further from your perspective that needs to be addressed here?
well, just one possible suggestion. If all this bonus pay is made directly from the father to the mother, not through Kansas Payment Center, then DCF would not need a specific judgment for each dollar amount, as we would not be involved in, I guess, caretaking the debt, the payment and receipt of that money. That's up to the parties, whether or not they want to journalize every bonus pay dollar amount or not. But also DCF would waive signing of the journal entry if both private counsel agree to the terms of the journal entry. DCF doesn't need to waste anybody's time getting it signed.
Mantell, is there any reason your client just can't make a direct payment with proper documentation to Jamie? And I trust that's where the payment would be paid to, despite the assignment to Jamie.
Yeah, I think whatever the proposed language is in the, if I think that, let me look at it. I thought that proposed a direct payment, but I think that's what he's fine. Whether he pays to the Kansas Payment Center direct doesn't matter. The money's still there, so it doesn't matter.
And let me just make sure, I'm sure you tell him the same thing, Mr. Mantella. Craig, don't pay it in cash, okay? Make sure that there's appropriate documentation of your payment instrument, whether it be your personal check, if it's a cashier's check, whatever it might be, make sure that you always keep a copy of your payment. I have had trouble in the past with cases where people tried to pay these amounts in cash, and there seems to be a dispute as to what was paid and what was received and when it happened. So hopefully proper payment documentation will avoid those issues in the future. So we will have the journal entry reflect it will be a direct payment from Craig to Jamie on these bonus amounts. Okay, I think I've gone around to each of the attorneys and addressed any of their additional concerns, but I'll ask collectively, anything further that the court needs to address?
No, Your Honor.
No, Your Honor.
Our motion asked for retroactive application to the month of filing, which is appropriate under the statute. That was April 1st for the application of the new worksheet.
That would appear to the court to be appropriate.
Just confirming before I draft. Thank you.
Okay.
Very well.
Ms. Luck, will you be preparing the income withholding order as well?
I can.
Okay.
All right. Thank you all for your appearances and arguments here today. If there's nothing further, this matter will currently be in recess, and this meeting may be ended for all at this time. Have a good day, folks.
Now, I always thought that workers' comp, granted, it does compensate you for lost wages, but it also pays you for future lost wages due to your injury. And it also pays for future medical bills that you'll incur in the future due to your injury. So when he goes to the doctor in the future because of this injury, say it's a lifelong injury that needs to be managed, is she going to pay 24% of that? I have a feeling she's not even going to offer. So I think that she's nitpicking every single penny. And as you can see, if you watched her, she's sitting there, it seems like calculating the pennies as she's sitting at the table. I don't know, I just think that's pretty cheesy. If mom needs to scrutinize every single dime that this father gets, maybe she should get another job, a different job, a higher paying one. That's just my opinion. Maybe he needs a higher paid job. I don't know. Maybe they're both underemployed. But it just seems kind of cheesy to me. Seems kind of greedy. That's just my opinion though. So thank you guys so much for watching, and I'll see you next time.